Anti-competitive agreements. Although this is a course on the law of contract rather than the law of competition or antitrust, I thought it would be worth touching relatively briefly on the issue of anti-competitive agreements, if only perhaps to pique your interest in reading about these further. This is one of the situations where Europe has had a major influence on domestic law, and indeed the framework for the prohibition on anti-competitive agreements comes from the Treaty of the Functioning of the European Union at Article 101. The general position on and prohibition on anti-competitive agreements comes from Article 101.1. It prohibits all agreements between undertakings, decisions by associations of undertakings, and concerted practices, which may affect trade between member states, and which have as their object or effect the prevention, restriction, or distortion of competition within the internal market, and, in particular, those which directly or indirectly fix prices or selling prices or any other trading conditions, those which limit or control production, markets, technical development or investment, those which share markets or sources of supply, those which apply dissimilar conditions to equivalent transactions with other trading parties, thereby placing them at a competitive disadvantage, and finally those which make the conclusion of contracts subject to acceptance by the other parties of supplementary obligations which, by their nature or according to commercial usage, have no connection with the subject of such contracts. Do take a look at Article 101.1 and read it for yourself. Here I'm going to draw on two particular elements of this prohibition. What is an agreement, and what does it mean to have as their object or effect a restriction and so on of competition. For the purposes of competition law, an agreement goes much further than the notion of contract, which we've been discussing on this course. A contract is, of course, an agreement for competition law purposes, but competition law also encompasses gentlemen's agreements, what you might consider honour-based agreements, as well as simply expressions of working together. Since the prohibition also covers concerted practices, it is clear that it is intended to apply very broadly indeed. A concerted practice does not require any form of agreement and covers cooperative behaviour, such as signalling a future change to a price, if others were to change their pricing based on that. For an agreement to be prohibited under Article 101.1, it must have as its object or effect the prevention of competition, and these are two separate things. The object restriction covers agreements which are, by their very nature, anti-competitive. This includes such things as price fixing or agreeing to divide the market up to avoid competition. This is different to the parties' intentions. The parties may not intend to engage in anti-competitive behaviour, but if their agreement, on its proper construction, has the object of restricting competition, it is automatically void. Because an object restriction automatically voids that clause or voids the agreement, there is no requirement for the agreement to have, in practice, any restrictive effect. The object restriction alone is sufficient to void the clause. Since concerted practices are also banned, even agreements which are not yet in force can be caught by the object restriction. For a look at how the European Court approaches the issues of object restriction, see the Alliance Hungaria case. Restriction by effect means that the European Commission has analysed the factual circumstances around the agreement, legal and economic, and of what happened once the agreement was implemented. As you can tell, if an object restriction can be proven, this is a far stronger basis for bringing a case for breach of Article 101.1. If the Commission needs to become involved in an effects analysis, there is far more scope for a company to argue in favour of its behaviour. For an example of an effects case, see John Deere from 1995. There is a statutory exception to these prohibitions, such that even if an agreement does have as its object or effect the prevention, restriction or distortion of competition, that part of the agreement or the agreement as a whole is not void. There are two aspects to consider here. The first is a series of regulations or exemptions which bring an agreement within the scope of Article 101.3. If an agreement falls within one or more of these exemptions, it is within the scope of Article 101.3. If it doesn't, it might still be exempted, and you would need to conduct an analysis against Article 1013 itself to see if your agreement falls within it. I'm not going to go through block exemptions in detail, and I've included a link in the reading with the materials to a website which sets out what they are. However, you may find that the block exemptions on vertical agreements, agreements between participants at different levels of a supply chain, and horizontal agreements between parties at the same level of the supply chain might be useful, as well as the technology transfer block exemption. There is also a notice on agreements of minor importance, the de minimis notice, which covers agreements which do not have an appreciable impact on competition. As I say, if your agreement does not fall within one of the block exemptions, or the de minimis notice, you would need to consider the exemption of Article 1013 itself. This exception covers an agreement which contributes to improving the production or distribution of goods, or to promoting technical or economic progress, while allowing consumers a fair share of the resulting benefit, and which does not impose on the undertakings concerned restrictions which are not indispensable to the attainment of those objectives, or afford such undertakings the possibility of eliminating competition in respect of a substantial part of the products in question. The conditions are cumulative, and so to fall within Article 1013, an agreement must have efficiency gains, allow consumers a fair share of these, not impose indispensable restrictions, and not afford the possibility of the elimination of competition. You have to satisfy all 4 conditions to fall within this exception, so if an agreement fails on any one of these bases, it falls outside the exception. Remember too that this exception only applies to agreements which are prohibited under Article 1011. If there is no prohibition, you don't even need to think about Article 1013. There is a guidance document published by the European Commission on Article 1013, and I have included a link in this in the materials. It is not an exception to Article 1011 to argue that you were forced into an agreement by a more dominant third party, and that you could not trade, you could not buy stock, if you did not enter into the agreement. It may have a mitigating effect on a sanction, but it doesn't stop you being a party to an anti-competitive agreement. In terms of sanctions, where an agreement contains a term which is prohibited under Article 1011, if the term in question can be severed, struck out of the agreement, that term is automatically void. You cannot enforce the terms of the agreement on your counterpart, which could have disastrous commercial consequences. Worse, if the term cannot be severed from the agreement, the entire agreement is void. See the case Société Technique Minière. However, there is also a highly punitive fining regime, up to 10% of global turnover for the previous year, and for particularly egregious infringements, what are known as the cartel cases, imprisonment is also available as a sanction. The aim of this legislation is to try to ensure that the internal market, the idea that Europe is one big market without internal barriers to trade, is not frustrated by companies seeking to carve up the market along geographic lines, restricting others from competing and improving the service received by consumers and lowering prices. If you are considering contracting within Europe, you will want to be very mindful of these rules to ensure that your agreements do not get struck down and that you're not exposed to potentially huge fines or even prison time.